Hey everybody, welcome to week two. Um, we're going to talk about two things this week. First is legislative information. So some of the core of what this class is actually about. And if you remember from last week, we're going to divide this into legislative in week two, judicial in week three, and administrative in week four so that we get all the branches of government covered. So this week is legislative information. And then we're going to talk about the legal research process and what are the steps in it and what we should and shouldn't be doing, some of which I alluded to last week when I talked about the unauthorized practice of law, which is jumping ahead to what we'll talk about next week. But some of you might actually have to do some analysis and interpretation of the information that you find, depending on who it is you're serving, where you work. So I wanted to make sure that you at least had a structure to use, should that be your situation, so that you know what to do and how to handle it. So the first thing I want to talk about a little bit is legislative information. This is going to be a deep dive into the law made by the legislative branch of government, be it Congress at the federal level or the state legislature where you happen to work. All of which, except as you'll read in the slides, Nebraska, which only has one house in its legislature. It's a unicameral legislature. Every other state has two, so that's bicameral. That's what we also refer to Congress with the House of Representatives and the Senate. We call it a bicameral Congress. So just understanding how laws are made, and there will be some slides and videos about the legislative process, including I'm Just a Bill from Schoolhouse Rock, which is older than I am, which is saying something. And while it might be dated and a little cheesy from a 50,000-foot level, it actually has the details down pretty well about how the federal government works in the process of making as far as the process of making law is concerned. I also give you links to congress.gov, which gives a much more current yet incredibly much more boring way of looking at how laws are made at the federal level. From a legal information standpoint, I do want you to understand the publication process of statutes. The first step, and this is very general, these can be generalized between the state and the federal level. You have a slip law. It's almost like hot off the presses, could be as much as a page, could be a booklet issued by the government. It says, here is the law, so that people have access to it as soon as possible. These are online these days. My library is part of the Federal Depository Library Program, do get the slip laws in print from the federal government. No one looks at them. If people need public laws these days in the form of slip laws, they just go to GovInfo and get them that way. So those are not particularly helpful. They're just one-off publications. We put them in a file on a bookshelf. Again, no one looks at them. But at the end of a legislative session, every single law that's passed gets published into a book. And these are session laws. At the federal level, session laws are the statutes at large. So you take a volume of the statutes at large, the very first law in that book was the first law published in that legislative session. And let's say it's on bankruptcy. The very next law could be on immigration. The very next law could be on securities. The very next law could be on housing. So there's no subject compilation organization. It is chronological order of every law that was passed that session. It's a snapshot of all of the legislative activity that happened during that session. That is not particularly helpful for most research that legal research that people do. Most legal research is much more targeted by subject. So you don't use the session laws for this. You want to use what's known as a code, a statutory code. Code coming from the word codification, which means organization by subject. So what happens is there is a keeper of the code, and for the federal code, which is the United States Code, there is an entity within the House of Representatives called the Office of Law Revision Council. And what the Office of Law Revision Council does is they take all of the laws passed by Congress and they read them over. And if they are of a general and permanent nature, meaning they affect everyone, and the intent of the statute is to be in effect for the foreseeable future, they take this law, let's say bankruptcy, and now they'll go to the bankruptcy code and the United States Code, and they incorporate the new law into what is already in existence. That's the process of codification. That's what people use more often than not, is a code. So in this class, I want you to understand the difference between a session law and a code. We won't be researching session laws. We will be researching codes, both federal and state. And speaking of how we're going to research them, there are 4 ways I talk about in the slides about how you are most likely going to be asked to do statutory research, either for an attorney, a judge, a faculty member, and what you do for the public in helping them as well. So sometimes, and this is the easiest of all scenarios, someone comes in and says, I have this citation. Can you show me where this is in a book? Can you show me where it is online? And so you'll just pull it for them. Nothing wrong with doing that. You're not interpreting anything. You're not analyzing anything. When you have a known citation, you just go pull it and give it to them and let them read it. Easiest scenario, dealing with the public, that is probably 99% never going to be what you get, but I'm just saying it is an option. The second is, I want to know what the laws are on DUI. So now you're given a subject. In this situation, what you want to do is you want to take the patron to either a print topical index for the statutory code, or you will take them to an online index to the statutory code if one exists. States used to never put their indexes online. They would just throw up an organization of the book, maybe in PDFs if you were lucky, but no way to search them. States are getting a lot better about that these days and making their statutes full text searchable, putting an index up. Maybe there's a popular name table, which I'll get to in a second, to help the public better access the laws that they're bound by. Third way, people know a law, they might read about it in the newspaper. The best example is the Patriot Act. You know, someone wants to read the Patriot Act. Extreme example. Well, the Patriot Act actually stands for something. I can't tell you what it is off the top of my head, but there's a tool called the Popular Name Table for the United States Code, where alphabetically you can go to the P's and find Patriot Act, and it will tell you not only what the PATRIOT stands for, but it will tell you where it existed in the session laws. It will tell you where it got organized into the United States Code, and I will tell you the Patriot Act touched so many different areas of the United States Code that it shows up just about in all of the 53 titles of the United States Code. And so that's another foray into helping someone find what they need. If you've only got a name, at least at the federal level, and for some states, there's a tool for that. Finally, full text searching. This is where you have a database where you can go in and look for certain terms to show up and figure out where they appear in the code. If you're helping the public do this, sort of, as part of your reference interview, talk about, well, what are the main terms that you're most concerned about? So going back to the DUI example, well, maybe there's an entry, or maybe it's called DUI, or maybe it's driving under the influence, or it's DWI, driving while intoxicated. But all these things you've got now, driving, intoxication, impaired driving, all of these things that you can use, but you don't come up with the words. You let them come up with the words. They need to be in the driver's seat a little bit for this, because what happens, and this gets into you possibly overstepping, is you're now analyzing their problem and helping them figure out the words that they need to get them into the system, to get them information. This is a fine line. You judge how far you're going to go if you have to help someone do this. But in the experience I've had, try to get them to I get them to sort of generate the terms. I'll ask questions and be like, oh, well, let's just start with that term that you just threw out there, and let's throw that into the search bar and see what we get. So we'll have an opportunity to use all of those research methods in the homework for this week. Another thing I wanted to bring to your attention is last week when we talked about the characteristics of legal information, one of the distinctions we made was between annotated and unannotated. You're going to see that this week. We have codes, statutory codes, that will either be annotated or unannotated. And the difference being the extra information. Annotated means extra. And annotated also means it's going to likely 99% of the time, probably 100, but I don't want to be that certain about it in case there is this one annotated government published code that exists that I somehow don't know about after doing this for 14 years. a commercial publisher is going to do the annotations. They want to do something that provides value added so that you will buy their version of the code. So you get the text of the code, you will get cases that interpret the statute as chosen by someone with a legal background. There can be tons of cases that cite a statute, but if the case itself isn't spending any time talking about what the text of the statute actually means, it's probably not very helpful. So an attorney editor actually is making this call as to which cases have some substantive meat on the bones talking about the statute, as opposed to just some tangential citation to it, and the case isn't even really about that statute. In week 4, we'll talk about law review articles and legal encyclopedias and American law reports. These are secondary sources. And these commercial publishers make money by publishing a lot of secondary sources. So what they'll do is, based on the topic of the statute, they will recommend law review articles and encyclopedia entries and treatise sections that interpret what this statute means extrajudiciously, meaning outside of the court system, because those are the cases that they give you. So other analytical material that really helps you understand what this statute means, the context in which it applies, the context in which it doesn't apply. So all of this stuff is incredibly valuable to attorneys and really anyone who is attempting to understand the law. So annotated codes are gold for research. The sad part is that, at least at the federal level, the 2 annotated federal codes are not official. The official is published by the government. At the state level, some states insist on publishing their own code. Sometimes it's annotated, sometimes it's not. In Nevada, we're very lucky that our official code is not published commercially. It's published by the state, but it's also annotated. That's unheard of. That is definitely the minority of jurisdictions that do that. Otherwise, you have either a version published by West, Thomson Reuters, or you have a version published by Lexis, and they're annotated. And at the state level, one of those versions will be official. And who decides? Well, the state. The state will say the version published by Lexis will be the official codification of the statutes of this jurisdiction. So then you know. For states, it's much less of an issue. So let's say you're doing some research and you think you found the section you wanted. Before you settle in and put your chips down on this being the answer, you need to look around. You need to review the statute that comes before it and the statute that comes after it, and you need to read it in context. You also need to look for a definitions statute. And that usually comes at the beginning of a set of statutes. So if there are 10 statutes, section 1 or 2 is probably going to be definitions. You have to read that section because those definitions apply to these 10 statutes. And the legislature, be it Congress or a state legislature, took the time to say, so that there is no confusion as to what a word means, they put it up front. So if there is a term used in that 7th statute down, you cannot assume it means what you think it means. You need to go back and see what the definitions section says it means, because that's the law. That is the definitive interpretation of what that word means. You will have an opportunity to research a definition section in your homework assignment. The other thing that I want you to be aware of is when you're looking at a statutory code and you're reading the text of a statute, there will be this gobbledygook stuff in parentheses at the end. And it's going to have like a bunch of numbers and dates and citations to other things that look, just foreign to you at this point. But hopefully by the end of this course, they won't. What this is a statutory history note. You'll see examples of it in the slides. But what this tells you is when this particular statute was first added to the code, and if subsequent legislatures since enactment have changed language, added sections, there is going to be a link to the session laws that will explain to you what the change was, and it will actually give you an indication of how many times it's changed over time. One of the reasons you look at session laws is because the law has changed from then, but you might actually need to know what the law was at a particular point in time. And if you do not have access to the codes in print from 20 years ago, and most libraries don't, there's just not enough shelf space to hold all of these things, you can go to the session laws. At that snapshot in time, you can see what the law was then. And that's an important legal research thing that you may or may not have to do. So that's kind of overview of things that I think are important for the legislative information section of the course. The second thing I want to talk about is the legal research process. So why are we talking about this? The full legal research process involves some analysis and interpretation. So this is taken from what I used to teach first years law students back when I was in academics. You take it from getting a fact pattern and analyzing, figuring out, is it civil or criminal? Is it figuring out, is this employment? Is it a contract issue? Any of these things. And then you go and you find research, but then you read it. And then you start synthesizing all of the things that you found, and then you come to an answer. Some of you, depending on where you work and who's asking for help, you may have to do this. So if you're in academics, you're going to have faculty members who may ask you to do some research and come to a conclusion. If you are working in the courts, you may have a judge or a Supreme Court justice come to you and ask you to do some research and come to a conclusion. And the conclusion requires analysis. You have to read all of these things and give an answer. Yes, the law applies, or no, the law doesn't apply, or yeah, it does, but only in these situations. If you work for attorneys, they might expect you to do some very basic level analysis. But when you're working with the public, you got to stop. You can't go that far. So you need to make sure that you're not doing the analysis for the public. That can get us into the unauthorized practice of law, which is a topic for week 3. But I wanted you to see, and there are several slides on the process, so that you can actually see how you go through it should you have to. But one of the things that you will have to do on the homework is an initial factual analysis, not a legal analysis, but a factual analysis of a fact pattern. It's hypothetical. You will not do actual research for this question. Do not do it. I put that in bold on the homework assignments just to remind you, in case you see that first before you watch this video. Don't do legit actual research. There is no answer. I'm not asking a question that requires an answer. What I'm asking you to do is read a fact pattern and generate search terms and think about this around 4 W's: the who, what, when, and where. And these are all important no matter who you're serving, because it's going to help you figure out in which direction you need to go to refer people to information. So let's start with the who. Legal relationships. Who are the people to one another? I don't care what their names are. Their names are irrelevant. I'm sure they're lovely people, whoever they are. But from a legal research standpoint, I don't care that her name is Mary and his name is Tom. I care if Tom is the employer and Mary is the employee. So there's an employer-employee relationship. So that's employment law. That makes me think, okay, I need to be sending people to maybe an employment law treatise. Or I maybe need to, if the state bar lawyer referral service gets to the point where they divide like specific phone numbers or email addresses, if you need a labor and employment attorney, then you know that that's how you're going to move someone forward. You're not actually doing anything. Doctor-patient, attorney-client, landlord-tenant. All of these legally recognized parent-child, husband-wife. So that's kind of what I want you to get at with the who, the legally relevant, factually relevant who. What? Other potentially legally relevant facts, such as maybe there was a contract between people, then that might lead you to resources that deal with contract law. And what is also like, what other information do you not know that you might like to know, or that you would like to know that you think might be helpful in moving this one step forward? Again, these are all brainstorming questions. The when is important for 2 reasons. One is statute of limitations, which some of you may have heard of before you ever came to this course. The law encourages people to bring suit for grievances in a timely manner. So you have, depending on the grievance, a certain amount of time to come to a court and sue someone. That's why you need to know when something happened. If something has a statute of limitations of 5 years and it's 2020 now, but the problem happened in 2014, you might be out of luck because the statute of limitations is run. So that is one thing to think about. The second thing, and this is much more of a legal nuance thing, is when things happen is creating a timeline. So, for example, in torts, we have this idea of negligence. And so if someone injured someone and you have injury, maybe there were some intervening things that also happened that aggravated, or one of these intervening things that might actually have caused the damage that someone suffered. Knowing the sequence of events is another thing that's incredibly important sometimes in law. So that goes with the when as well. And finally, where. Where is so important. Where is also important for two reasons. One, and the biggest, is jurisdiction. So you have someone come in to your library and they're like, I feel like someone has infringed on my copyright for this song that I wrote. Okay, well, the first thing is you hear copyright, jurisdiction. Copyright is federal. The last thing you would want to do is now send someone to a state statute and start looking up copyright infringement. There might be somehow a state cause of action for this, but copyright is federal law. You would then need to refer them to the United States Code that deals with copyright. You could lead them now to, if they're looking for cases, and you can advise it this much, and if they say, I want to sue in the Ninth Circuit, well, then you know to make sure that you're not looking at cases from Kentucky, for example, which is in the Sixth Circuit. So jurisdiction is incredibly important as far as where things happened. Another example is, there are certain rules for different places where events occurred. So for example, a bunch of kids venture onto some vacant farmland and they find this barn and it's in disrepair. Well, it is kind of legally relevant that these kids may have gotten injured there if the owner didn't do something to sufficiently cordon off the area, post signage, no trespassing, possible danger, all of these things. So that's also not related to jurisdiction, but it could be legally relevant as to where things happen. So I want you to be able to think about that as well. Why do I go through all of this? Because I didn't do this in the video last year. One, students did actual research. Even though I made up a town, they somehow did research. Don't do actual research for the question, and you'll see it on your homework. But this is the first step in the legal research process. And while you may not do the analysis at the end for the public that you serve or students that you serve, I wouldn't advise doing this for students either. At some point, you need to teach them how to do this research, give them some guidance on what they should be looking for. But it is good for referrals. It is figuring out what among all of the legal resources you may have access to, which ones are actually going to give you a good answer. So that's it. I think I went a little longer this week than I planned for, than I did for last week, but hopefully there's some good stuff in here that will help you as you move along. As always, email me if you have questions. Email me at jrsowards@gmail.com. It goes directly to my phone. If it's a question you think everyone needs to know the answer to, then use the question form in Moodle. There is a quiz this week. There's a quiz every week. I highly encourage you, again, to do it after you watch the videos and read the slides. Just take it, knock it out, be done with it. But again, you have till the end of the course if you want the flexibility to do that. There's a research assignment. It'll be, I think, a little harder than last week. I don't think substantially harder, but I think it will be a little bit more challenging. And you'll also get back your graded first week assignment this week. And so there will be an opportunity to resubmit, but you can't resubmit after the week 2 deadline. I consider the week 2 deadline, we're moving on. If you didn't submit it during the first week, then you didn't want to redo it. And that's fine, totally up to you. But we at some point have to just move on to the next thing. So again, I hope you enjoy this week. We're actually getting into the meat of stuff. And yeah, email with questions. Thanks.